here on behalf of the defendant and appellant. I'm here with our paralegal, Natalie Young, and just want to say that we really appreciate you being here and listening to our argument in this case. I'm first going to start, for the sake of argument, to discuss...
Do you want to reserve any time?
Oh, yes, I apologize. If I could reserve 4 minutes.
4 minutes, okay.
Thank you. This matter stems from a motor vehicle accident. And at the first trial, which I'm going to discuss our issue for review, which is the disclosure, or the court allowing the expert witness to testify. And then I will discuss the motion for new trial and whether or not that bars our ability to file this appeal, whether we waive it. So at the first trial, which we were not counsel on, the 2 weeks prior to, or 2 weeks before the start date of the trial, defense filed a motion to exclude the expert witness. And this was a accident reconstruction witness, or expert witness, and it was based on the fact that Rule 26 disclosures were insufficient. At that point in time, they'd only provided a report that essentially said plaintiff had stopped at the stop sign, defendant went through the stop sign. There was no other basis. And instead of the plaintiff providing additional disclosures, he stated that it was on us and our fault that we did not have that, and that it was our duty to do depositions of the expert witness. And because we had chosen not to do depositions of the expert witness, that's our problem, and that he had no obligation to disclose the information that you would assume and seek in Rule 26 disclosures. However, there's no obligation for us to ever take an expert's deposition. And in fact, there's a lot of strategic reason for not taking deposition, because we want them to testify live at trial. So unfortunately, the court allowed the expert witness to move forward with, or allow the expert witness to testify in trial despite those deficiencies. And the court, in doing this, cited to the rules of evidence, specifically Rule 703 and 705, stating that the Rule 705 did not require disclosures such as the equations, the methodology, and supporting evidence for the opinion, that they weren't required. While the rules of evidence are for admissibility of evidence and testimony in trial, we're still dealing with a pretrial matter. However, you'll see throughout this entire matter that both counsel, or plaintiff's counsel, and the trial rely very heavily on Rule 703 for grounds as to why they didn't have to provide sufficient disclosures. Well, unfortunately, when we got into trial, we don't have any of the information. So counsel did try to get clarification from the judge as to what the expert was going to be allowed to testify to on direct. And essentially, the judge said, well, let's just see what happens. So that's what happens. And on direct examination, the expert witness starts testifying as to calculations. And he at one point draws a calculation. And it's admitted into evidence as to how he calculated speed.
Counsel, wasn't the understanding here, and going all the way back to the initial denial of the pretrial motion, that that this was going to be a matter that was going to be explored at trial on cross-examination? So the prejudice here, and why isn't it on essentially your side of the case here, the failure to conduct discovery and become informed about what it is you were going to cross-examine the witness about? Doesn't that prejudice arise from sort of failure to conduct discovery?
Well, I would state in response to your question, that Rule 26 disclosures require parties to disclose a certain amount of information and the basis of their experts' opinions to opposing counsel. And, part of that is to allow the other party the ability to be prepared to cross-examine at trial. And there isn't a obligation that we depose an expert witness if we don't want to. If we don't want to just depose an expert witness, I don't think it forgives their right or obligation and duty to provide Rule 26 expert disclosures. Does that answer your question?
Why isn't that a step that essentially, in terms of appeals, and if you can avoid a harm before the trial court, and it seems like insofar as your argument is related to we didn't know,
Yes.
that seems a bit self-inflicted here. Now, I mean, that's a different issue in terms of limiting scope of cross-examination. Mm-hmm. But when you're talking about we didn't know what to ask because we weren't sufficiently informed because we had the disclosure, and you had an opportunity to conduct discovery, that seems a bit self-inflicted to me.
No, that's a point, and I definitely see where you're coming from on that. And I think the difference is that we could have, are you suggesting like we could have deposed the expert witness before the trial?
Well, insofar as your argument, and I think I see two veins of your argument here. One, limiting the scope of cross-examination, but from what I'm hearing so far, you're also talking about prejudice in terms of lack of understanding. We didn't know what to ask because we didn't know. But insofar as your argument is related to we didn't know what to ask because we didn't know, you had the pretrial ruling, and you had the trial judge saying, well, I'm going to let you cross-examine. We're going to get into that. We're going to see how it all unfolds. So I'm struggling to see why that aspect of your argument is not a self-inflicted injury here when you could have addressed that through the discovery process.
Well, I think, when we get to a cross-examination, you'll see that the court shuts down basically all of the, substantive cross-examination. Doesn't allow him to ask about the equations that he just testified to on direct. And, I recognize I'm not trying to play or hide a ball anywhere. And, the reality is that part of my question is, why was it so difficult to provide disclosures, even if it's just the basis, when literally their report says defendant drove through the stop sign, plaintiff did not. But again, I recognize what you're saying, and I wish that we had been able to come to a resolution, but I know that plaintiff was of the opinion that they had done their part, that under Rule 705, their report was a sufficient disclosure, and that they were not required, they had no obligation to disclose anything more. And instead, they imposed the duty on us to depose the expert witness. And then when we get to the trial and they're testifying, for example, when the defense counsel asked about where the equations were in the report, the expert report, plaintiff's counsel objected and said that we could not ask that question because that question implied that he should have something in the report, and by not having it in there, he's doing something wrong. And then the judge sustained the objection, and effectively we weren't able to ask about any more questions about the calculations that he had just provided to the court.
Were you curtailed from asking questions about the basis of the expert's opinion, or just simply whether that basis was reflected in the report? Because those may be two different things, right? In terms of, did you put your calculations, did you put your scientific understanding of why you reached this conclusion in the report versus being able to ask the expert basis questions in cross-examination to get to not what was and what wasn't in the report, but what was the basis of the expert's opinion.
Yes, and I think, it's kind of a two-part. It was first getting all the information from and trying to understand what information the expert had used. For example, did they only calculated one calculation for one of the vehicles for speed, not the other? And trying to understand that, and then from there build be able to effectively cross-examine, but they were never given that opportunity. And I will show you that at the second trial, I see I'm about to run out. At the second trial, the court, the plaintiff's counsel files a motion to deem unavailable, and based on the fact that Mr. Smith had died. And part of 804, Rule 804, is not just the unavailability, but also that they had had an opportunity to effectively cross-examine the witness. And I think you can just see, this is the transcript from the testimony with Dr. Smith, and this is where it starts on the cross-examination, and you can see very clearly how the whole thing's essentially redacted. I mean, all the cross-examination, I don't even know why they include some of these black pictures. Cross-examination was very limited, and I know I'm about to run out of time, but I know plaintiff's counsel even uses the right word. He said it was shut down. He said counsel was shut down, and we agree.
Thank you.
May it please the court, Eric Beasley for the Appellee. Your Honors, the first thing I'd like to bring up, just very, very briefly, is the first matter Appellee would like to address is that the appellant failed to file a post-trial motion regarding these matters that are on appeal. Rule 4 of the Tennessee Rules of Appellate Procedure require that in jury trial cases, any ground not cited in a motion for a new trial has been waived for the purpose of an appeal. And failure to file a motion for new trial dates denies the trial judge the opportunity to consider or reconsider alleged errors committed during the course of trial, and it precludes the appellate review of that issue. In this case, the appellant not only did not file a motion for new trial post-trial, they didn't file any post-trial motions. And as such, all the issues presented by the appellant today should be waived and the appellant's appeal should be dismissed. But in the event that you do not deem that the issue...
Are there any exceptions to that rule?
The exceptions to that rule that they cited dealt with unfair prejudice. I think they went into talking about some of the issues that were involved in this case, not having the ability to cross-examine. I will actually address those in a moment, if that's okay, Your Honor, because I do think that for the case that they cited, or the rules that they cited, that motion, or the failure to file a motion for a new trial should not apply, really kind of go to the heart of what their appeal is all about, I guess. And so, as to not double speak, would it be okay if I address that in just one moment, Your Honor?
Sure.
Okay. So, but we'd like to respond to those other issues, and to help make more chronological sense, because this is kind of an odd situation that happened. I'd like to respond to the issues as they pertain to the first jury trial of this matter that ended in a hung jury, and then speak to the second jury trial of this matter. And to help put things in context for the court, it's important to explain that Dr. Winthrop Smith was an expert that we had retained to offer his opinion testimony as to the cause of a motor vehicle accident. This was a four-way stop, and there was a dispute as to who ran a stop sign and who didn't. Our expert offers that Dr. Smith offered his opinion testimony at the first trial live, and a couple of weeks before the second jury trial, he unexpectedly died. And so the issues presented by the appellant, as you know, this is really kind of centered around Rule 26 of the Rules of Civil Procedure and Rule 705 of the Rules of Evidence. And it's an abuse of discretion standard on this matter, and we implore this court that the trial judge made discretionary calls. There's no reversibility here.
Counsel, in denying the pretrial motion here, and the trial court did seem to convey that there was going to be an opportunity to address these foundational basis issues in cross-examination.
Sure.
And then it seemed to curtail some of that in terms of cross-examination. And was there really a full opportunity to cross-examine in this case with regard to the basis of the opinion, or was this a circumstance where the expert kind of got to say, here's my opinion, here's how I reached it, and the other side didn't really get to cross-examine him at the foundations?
No, Your Honor, and I know that is the heart of the appellant's brief. What actually had happened is when the expert took the stand to testify, he testified freely. The attorney for the appellant in cross-examination tried, in reading of the trial transcript, this is very, very evident, he was trying to get items to the jury that the judge had already ruled in a pretrial motion were not admissible. The two main items that he was trying to get the expert to say is, one, he didn't ask about the calculations. He already testified under direct examination as to what his calculations were. He wanted to ask the expert, why are there no calculations in that report? And the trial judge correctly told him, that's not a matter. You're trying, because my objection was he's trying to make the jury think that this expert is trying to hide something or be deceptive. The matter of why the calculations weren't in the trial support all went to the heart of Rule 705. The calculations are not necessary, and that is the plain language of Rule 705.
So your understanding of so as we go through and are reading the transcript in this case, that those objections, and there's a significant number of objections that were made, yes, and a significant number of them that were sustained in terms of the objections that were made, that what we're going to see is that was an attempt to refight the pretrial motion or go behind the pretrial motions in this case, rather than objections that were preventing an exploration of the underlying basis of the expert's opinion. So when we're going through there, that's what we're going to see in this case, rather than they couldn't get at the calculation or why that was the number or sort of what the expert was relying on.
That is 100% correct, Your Honor. He wasn't asking why are your calculations like this or anything like that. It's just why. His question clearly was, why are the calculations not in your report? And then he moved on. One of the other focuses of his cross-examination was trying to get the expert to testify as to the contents of the police report. Early in the case, I filed a pretrial motion requesting that the trial judge, because we had subpoenaed the police officer to testify as a fact witness only, and a pretrial motion requesting that the court rule that the officer could not offer opinion testimony unless he could be tendered as an expert, qualified as an expert. And he was unable to do that right as the trial started, outside of the hearing of the jury. We both direct and cross-examined the police officer. The trial judge determined he could not testify as to his opinion of the contents of the police report. So, flash forward to the attorney for the appellant cross-examining the expert. He was trying to get in the contents of that police report through the expert's testimony, and I was objecting to that. That was the other big thing.
Part of the basis, though, of the expert's opinion? I mean, isn't the expert taking calculations from that police report in this case? Well,
as I'm sure you know, Your Honor, the actual police report is completely inadmissible at trial. The contents of the police report are admissible, but the officer's opinion is not admissible.
Why can't the opposing party then explore, though, the advantages of sort of the expert? And I take it as one of the questions, maybe I'm wrong about this, but I have a recollection that one of the questions here relates to you didn't go to the scene and do these measurements yourself. And if I recall correctly, there was an objection that was sustained in terms of pushing on why didn't the expert go to the scene. I mean, isn't that a legitimate basis of exploration in terms of the expert's opinion? I mean, the expert's relying on the police report rather than going and, I mean, maybe the officer miscalculated the distance between stop sign A and stop sign B. And why isn't that a legitimate basis question rather than a looking behind the pretrial motion question?
It is a legitimate basis question. You're completely right, Your Honor. The question was being objected to because he was trying to paint to the jury, and I know it's hard to read that from the transcript, but I can only tell you as the trial attorney that was there, he was trying to get the jury to discredit the expert by saying, oh, you didn't go to the site, when the expert clearly testified, I don't need to go to the site. As part of the materials the expert used to derive his opinion, all of which I will note were provided to us by the defendant, In addition to the deposition transcripts, what he testified to is you provided aerial photographs. Google Earth tells me all the calculations to the inch that I need to be able to derive any calculations I would have been able to make on site. Now, this is not part of trial testimony. Our expert came to trial just having had both of his legs amputated. He had been in a rehab hospital for 2 weeks learning how to walk again. I don't know this because he has passed away. This was not asked of him, but I'm sure that played into it at some point. But he did testify under oath from the stand. I don't need to go to the site to do it because all the calculations and materials I have are in the materials I used to derive my opinion. Does that answer that question, Your Honor? Yeah, okay.
Before go-
I don't want to move on if that question had been answered. But again, I don't want to stray too far away of what the tactic was and the reason that cross-examination was limited through proper rulings by the trial judge. But the reason why is he wasn't asking him anything about what was on the report other than trying to get the expert to testify as to improper opinions by the police officer on the accident report. And I apologize.
No, in ask questions to opposing counsel, I raised the idea that perhaps there's some self-inflicted injury here in terms of the lack of knowledge of the underlying basis of the expert's opinion. Can the discovery process really cure, though, an improper disclosure? And if we have an inadequate disclosure here, can discovery really, you really have to do that to fix it?
Well, I really hate to take the position that the disclosure was inadequate because our brief really
Let's accept for purposes of argument. So you're not agreeing that it was inadequate, but for purpose of argument, let's say it was inadequate. And is that something that it's needs to be cured through the discovery process?
I think it can be cured through the discovery process, but it certainly shouldn't be it's not the obligation of the appellate court to cure that. The cure for an inadequate disclosure, as we detailed in our brief, is to take the deposition of the expert. We provided a full expert disclosure as required by Rule 26 and a report and even other items that they asked for a full 10 months before the jury trial. They chose not to take that deposition. As we had written in our brief, it's not our job, the job of a diligent attorney, to do the job of a less diligent attorney. In addition to that, if they thought that our disclosure 10 months before the jury trial was not adequate, they could have filed a pretrial motion telling the judge, hey, we want more information. They could have done that. They could have served written discovery. These are all remedies that they could have taken to cure that problem instead of just waiting to the jury trial and trying to get in improper evidence to the expert that they weren't allowed to because of pretrial rulings by the trial judge on pretrial motions. I'd like to also, and I think it's important to point out that the appellants have argued that there's a trial by ambush here, and the facts on the record do not support this at all because they were aware of Dr. Smith's opinions. They were aware of all the materials that he used to derive his opinions, again, all of which we received from them. The bottom line is we did all that was required under Rule 26 leading up to the trial, and they failed to do their work by taking his deposition or petitioning the court for more information. I also would very much like to bring up a second matter in the brief amount of time I have, but some facts to understand what happened at the second trial. The first trial ended in a hung jury. The second trial, when we went to trial on that one, we filed a motion with the court alerting the court of Dr. Smith's sudden passing. We asked the court to deem him as being unavailable pursuant to Rule of Evidence 804. And as a matter of this court, I do not see anywhere in any of the appellant briefings that the appellant has disputed that Dr. Smith was unavailable. And the appellant's argument is that Dr. Smith's testimony should have not been allowed in the second trial because they were not afforded that full and fair opportunity to cross-examine Dr. Smith. And as we've just discussed, this is not true at all. But in terms of calling a, quote, full and fair opportunity to cross-examine Dr. Smith, the defendant argued that the cross-examination during the first trial was severely limited by the court, and this was not true. Because in our brief, we went through the entirety, even though you saw all kinds of redactions, what was given to the jury in the second trial, those were all redactions done by agreement of the parties. It wasn't by a judge's ruling. In our brief, we went through the entirety of Dr. Smith's testimony at the first trial, and we pointed out every single objection that was stated by the appellant and how each ruling to each objection was properly made by the trial judge regarding each of the appellant's objections. And obviously, time constraints don't allow me to go through each objection, and we've already focused on, I think, which were the two main objections, that of no calculations being in the report and trying to get in that police officer detail. But it's important to remember that it was the appellant's attorney during the first jury trial trying hard to get around the trial judge's prior rulings and get trial testimony to the jury that the judge would not allow to be entered into evidence. But it's also very, very important to note that the appellant's cross-examination was not prohibited by the trial court. The trial court allowed a cross-examination. And also, the appellant's cross-examination was not ended by the trial court, but instead, the appellant closed his cross-examination by choice. And it's apparent from the reading from the transcript, not only was this his choice, but it was done so out of frustration of not being able to get into evidence items which the court previously ruled were completely inadmissible. And I'd like to also point out that in their brief, the appellants have repeatedly characterized themselves as being new attorneys. In fact, I think I even heard that today during the beginning of the argument. They are not new attorneys to this case now, in the second trial, or in the first trial. This is not true at all. Any argument these attorneys are different lawyers than those at the first trial is completely disingenuous. Attorney Joshua Offit's office filed the answer to the original complaint. He and this office have been the attorneys for State Farm the entire time. In fact, he was the trial attorney on the second trial, and there have been at least 10 attorneys whose name have been on this case from his office, but hopefully this court's not persuaded by the argument of new counsel being an excuse, as any precedent created by doing so would result in firms firing attorneys just to gain an appellate scapegoat. Thank you, Your Honor. Very much appreciated.
Thank you. Ms. Greer?
It's Gear, actually.
Gear, oh, excuse me.
Everyone loves Greer, don't worry about it. First, briefly, I will state that his argument as to how to remedy the non-disclosures, one of those being filing a pretrial motion. Well, that's exactly what we did, is filed a motion to exclude the expert witness for inefficient disclosures. Second, I wanted to address really briefly the situation with the attorneys. Again, this was a motor vehicle accident. When the case was initially filed, we were retained as under unnamed defendants, so the UM carrier. And then over a year later, actually, is when Daniel filed a notice of appearance representing the named defendant. And as is pretty, customary in these cases, when there is a unnamed defendant and named defendant, counsel will talk, and one of the two defense attorneys will take over and move forward with the trial. So our office wasn't at the trial. I know there was another attorney that was sitting second chair with Daniel at the trial, but no, we were not at that trial. But we did take over after the first motion, or the first trial was ended in a non-suit. In regards to a motion for new trial, we would say this is a plain error rule, and that under Rule 36B, it sets forth essentially situations where you're not required, where you have the right to appeal as a right. And in this situation, the purpose of filing a motion for new trial is to preserve the record on appeal. And the trial court wants to make sure that they, one, give the court the opportunity to fix whatever error, but also preserve the record. And in this case, there was a motion filed. We filed several responses back and forth. The court made a ruling, and then it proceeded to trial. So we would present that the record here is preserved. So
Counselor, are you saying plain error is the appropriate standard in this case?
in terms of why We are,
In terms of review, how the court assesses it, is that the right way of looking at this, is a plain error analysis?
I would say that it's an abuse of discretion of the court in their decision to allow or to deem the expert witness as unavailable, that's an abuse of discretion. In reference to the plain error, I'm referring to the right to appeal, and that
And normally when a court is thinking about plain error, it has its own standards, right? And so are those standards something that we should be applying in this case, in your view?
I think in Rule 4E, there are situations where you are required to file a motion for new trial before you have the right to appeal. If you do not file a motion for new trial, or there are issues that you don't bring up in that motion, those are waived on appeal. And in this instance, we are stating that the record has been preserved. There was a motion filed, it was litigated, a decision was made, and hypothetically, if we were to file a motion for a new trial in this matter, I guess asking the court that they grant us a new trial and then reconsider their findings on the expert witness, and I would venture to guess that we would get denied, but I would put to the court that we wouldn't be in any different situation than we are right now if we filed that motion. In fact, it just would have caused further delay and more litigation cost. So that's why in this situation we are asking that the court grant our appeal and remand the case for new trial with instructions on the expert witness.
Thank you very much.
Thank you.
Thanks to all of you. Would you call the next case, please?
Thomas West versus David Garagano, Tennessee Commissioner of Revenue.